the issue of jurisdiction, it's my understanding that the government believes this should be, the CVIS record termination should be handled through the removal process. Why is that incorrect in your view?
So as we pointed out in court today, this is the only forum by which Ms. Öztürk can seek reactivation of her CVIS record and remedy the harm being done against her through the termination of that record. And as explained in court today, it is not possible for Ms. Öztürk to obtain that relief through the immigration court process.
Can you just explain why it's important that she be re-added to this database for foreign students? What are the practical implications for her?
Because of the termination of her CVIS record, Ms. Öztürk is essentially being treated as someone who is out of status and therefore can't work on her university campus, even though, as the government amply concedes, she has maintained lawful status, done nothing to violate the terms of her status, and really is being stripped of the indicia of lawful status through this action of terminating her record.
She is in her final year of study. Will she be complete in May? And what will happen? What will she do after May after she completes her studies?
So we're not going to go into her own individual plans, but this is, as we said in court, this is the final year of Ms. Öztürk's studies here, so we have a limited time to make this right for her. She has not been able to fully engage as a scholar and as a graduate student since her return to the Tufts campus in May, because the government continues to fail to reactivate her student record. And that's why we've said to the court that it's vital that the court intervene to ensure that she can receive the full benefits of her graduate education before it's too late.
But does she consider herself a foreign student or an immigrant to the United States?
I'm not going to answer that question.
Could you be a little more clear about what she's allowed to do and what she isn't right now? So she can attend classes, she can't teach, she can live in campus housing, but she can't do research or...
So I'm going to stick to what's in the papers of the case here. Ms. Öztürk cannot work. The government does not dispute that, even though she should be allowed to work because she is in valid student status, they have eliminated her ability to work by terminating her CVIS record. She is otherwise allowed to be a student on campus and is a student.
The government said the issue might be resolved by the immigration judge. Do you have any timeline on when that judge will make up their mind?
The issue is not going to be resolved by the immigration judge. As we've emphasized in court, that's a separate proceeding.
But they said the CVIS status record could be reinstated if the judge ultimately decides that she can stay.
Nothing that happens in immigration court is going to automatically fix this problem. And moreover, nothing would fix it immediately, which is when it needs to be fixed.
I mean, I think...
Before telling us your name, please.
Adriana Lafaille.
Will you spell it for us, Adriana?
Yes, ADRIANA-LAFAILLE.
And do you represent Ms. Öztürk through the ACLU?
I'm an attorney at the ACLU of Massachusetts. I'm part of the legal team.
Thank you.
Just one more question, please. Thank you.
Oh, I just wanted to follow up on what was asked related to what can happen in immigration court. I think it's fascinating to see that the Trump administration continues to try to funnel everything through the immigration courts because they know that they have complete control, essentially, of what happens there, because these are not independent Article 3 judges, and the fact that there are fired over 90 immigration judges at this time, and there are millions of cases in backlog. So why the Trump administration would try to funnel all of these cases related to First Amendment rights, constitutional rights, to the immigration courts should be something we should all be asking ourselves.